So right now, myself and Kat Walsh, we're going to talk a little bit about Creative Commons, past and future. Come on up and take a seat. Kat Walsh is the General Counsel for Creative Commons, and I'm a co-founder, even though I basically launched it and left to go get my graduate degree in 2003, I want to say. And but I worked on it with Aaron, and so Kat had the idea of us talking a little bit about that, and then she can tell you more about the direction that Creative Commons is going now and what the plans are. All right, so Kat Walsh.
Great, thank you. Make sure you can hear me. Thank you, it's great to be here today, and especially to have Lisa. When she emailed CC asking like, oh, would somebody like to talk about CC for Aaron Swartz Day? I thought about like, oh, it would be great to talk about the past and the future, especially since Aaron was such an integral part of Creative Commons past, and he should be here for the future. But and then I thought about it for 30 seconds, realized like Lisa is right there. It would be very silly to talk about Creative Commons past without having her on stage. So I feel a little bit like introducing CC to this crowd is probably saying things you all already know, but just in case. It's a global nonprofit organization that founded in 2001. The first licenses were published in 2002, and we're coming up on the 20th anniversary of those licenses. And in fact, for those of you in the San Francisco area, we're having a party for our 20th anniversary this week, and all of you are invited. We hope to see you there.
Thursday night, the 17th of November.
But we are a global nonprofit that helps overcome legal obstacles to the sharing of knowledge and creativity. We're best known for our suite of free open copyright licenses that are a simple, standardized way to share knowledge. They're widely used in open access research and grant making and sharing creative works. One of the first major adopters, in fact, of the license was Cory Doctorow, who you just heard. And we had a great interview with him earlier this year on our Open Minds podcast, in which I asked him about 5 questions, and then he goes on to talk for about an hour and a half, and very few of that material is repeated. So if you loved hearing Cory talk before, you should listen to that podcast, and he will tell a lot of stories about the early days of Creative Commons and his career as a writer and how he got into the free and open movement, and it's really great. But back in 2001 or so, around the founding of Creative Commons, like copyright law was having a moment, especially in the United States, which is where I'm most aware of it, but really everywhere, because of the explosion of the internet and people sharing material on the internet, and sharing material on the internet in ways that were uncontrolled and scary, and people weren't getting a cut of all the money coming from that, and people weren't controlling where that went. So a lot of legislation popped up in response to that. One is the DMCA, the Digital Millennium Copyright Act, that puts a whole lot of limits on the ways that you can share material and what you can do to like unlock encryption, like what you can do to break the restrictions that people are trying to put on this content. But the one really most relevant to Creative Commons is the Sonny Bono copyright term extension. And copyright was already pretty long at the time. And the Sonny Bono Copyright Term Extension Act extended it from like life of the author plus 50 years to life plus 70, and that's a really long time, especially in the United States, where we think of copyright not as a moral right, really, but as an economic right. As a way to get people to create more things, we will give them exclusivity for a limited time. But that limited time was getting less and less limited as time went on. And particularly for a lot of people who were expecting things to come back into the public domain so that they could give them new life. A lot of works that had been abandoned by the rights holders, or, not that economic value and the cultural value was just sitting fallow. People were waiting to give that new life, to have the right to do that, and all of a sudden they weren't going to be able to do that. And one especially was a publisher, Eric Eldred, who took material that was in the public domain and republished it, gave it new life so that people could enjoy it again, made it public, and was counting on this material, and all of a sudden, like, the rug got pulled out from under him. And a few other publishers who were in the same position, like, also were joined in this suit. And a couple of, nerdy law professors took an interest in this, including Larry Lessig, who's the the big voice behind Creative Commons. And while they were waiting for the outcome of this case, they were thinking like, let's do something about this problem. Like, what can we do to solve this problem while we're waiting on this case, especially like on the off chance that it comes out the wrong way and the Term Extension Act is upheld and these works don't go into the public domain. So it was just going to be like a little hack, something somebody could do with copyright law, like, you know, if you wanted to actually give your work away, if you wanted to let people have rights. And as it turns out, a couple years later, the Copyright Term Extension Act was upheld. Those works did not enter the public domain, and in fact, works have not entered the public domain in the United States for quite some time, and they're just about to. This will be, you know, or they've just been starting to, which is very like exciting. But in the meantime, that hack got a lot of traction, and one of the people around at the founding of this hack was Lisa. So I want to ask, like, what's your superhero origin story? Like, how did you get involved with CC?
That's kind of a crazy story. It's funny because Corey was here. Corey was around for that too when that happened. But basically, I was looking for something to do. It was 2001, and I noticed things were happening around Napster and things like that. And a Russian programmer named Dmitry Skalarov got arrested trying to leave DEF CON in Vegas. The feds do what they still do every year almost to this day, and hang out at DEF CON and decide who they're going to arrest on the way out. And in this case, it was Dmitry, who had a wife and 2 kids back in Russia. And the company he worked for, Elcomsoft, was actually had law enforcement contracts and stuff like that, but they exposed Adobe's fake encryption. And Adobe messed with them for a while, and then there were protests, and then Adobe said, we don't want anything to do with this. And then the feds said, we do. We'll say it. So Dmitry got lost for a couple days in our prison system when they were moving him around, and people were writing me, and I was like, somebody's in jail for a copyright thing? Like, I just didn't, you know. So that's what set me off. And then I found out that I didn't actually graduate from college because I was teaching for UC Berkeley Extension, because they needed an XML person, and there weren't that many, and in 2000. So I had to go back and finish my degree. So I moved back from Seattle to San Francisco. So that's why I was here when it happened. And Corey took me around. I met Corey as soon as I got here. I kind of interviewed him for O'Reilly. I was working for him, and then we hit it off. We were hanging around. Corey introduced me to Brewster. He introduced me to Lawrence Lessig. and I was just really intrigued by the whole thing. And there was no way that I thought I could actually get involved, and I had little to no understanding of anything that was going on. But then Corey introduced me to Cindy Kahn and Fred von Lohman at the EFF, and suddenly I was a webcasting expert. CNET called me a webcasting expert, one article. And so we were at the P2P conference in DC, and I was hoping to be invited to the O'Reilly dinner. And I hung out in the lobby and waited, and everybody looked right at me and walked out the door to dinner, did not invite me along. So I went off to dinner with another editor and got pretty drunk, and came back and went down to the bar just to talk for a minute before, we called it a night. And we were down there for about an hour talking, and then the editor left, and I looked up, and it was me and Lawrence Lessig at the bar. And I didn't want to say anything, because he was on his laptop, he was talking, he was doing something, and I didn't want to be that person that was like, oh my God, you're so cool, remember we met a month ago. So I just sat there, and then he looked up, because we had met once before, and I had told him I was an XML geek who was obsessed with copyright law. And he looked up from his computer, and he said, we've met before, haven't we? And I said, yeah. And he said, what's your thing again? And I said, I'm an XML geek that is obsessed with copyright law. And he closed his laptop and said, oh, I have a job for you. So that's how that happened. And then he said, you're employee number 1. Molly Van Houweling is running this thing. Talk to her, and that's how it happened.
Yeah, that's like, and I will say Molly has been involved with CC since the beginning. She's still involved. She is just about to end her final term as the chair of our board. So it's been great to have her.
Teaches over at Harvard. You don't have to mute me, just leave it up. She teaches at, not Harvard, no, Berkeley School of Law. Yeah, and she was at Aaron's Memorial, and we're in touch.
So when did you start working with Aaron? Because I know you were one of his early mentors, or maybe that relationship went the other way.
It definitely did. I didn't teach him much of anything except being his big sister kind of in the world. Anything technical was definitely him teaching me. And what happened was, and me and Larry both thought that Aaron, so I stalked the mailing lists, mainly the W3C mailing lists for XML and RDF, and you're basically reading and learning and figuring out who actually knows what they're talking about on these lists. And I told Larry, hey, I know the guy that we need for this. He has these wonderful answers on the list. He's really smart. He's probably one of these old SGML guys, because there was all these older SGML guys that had already been through it all, you know, in the 80s and 90s. And so he's like, what's his name, you know? And I'm like, oh, it's Aaron Swartz. Larry's like, yeah, I don't think he's an old SGML guy. He's written me. And, you know, he thinks that we should do an RSS version of copyright law. And I said, oh no, copyright law is much too complicated. That'll never work, you know. And then, like, within a week or two, Aaron had done it. He had given us an example and showed, oh, it's really, you're just saying yes or no to this. Do you want this? Do you not want that? You know, kind of thing. And Molly understood it right away, and they were just like, you're wrong, take another look. And then there it was, you know. So he got me on IRC for the first time. He explained to me how with XML that, you know, you really didn't need valid documents, these complicated DTDs that validated everything, that was really just would slow things down, especially like in a browser. It made no sense. And he was very, very polite, but matter of fact, when he was just like, Lisa, you're wrong. And let me tell you why. You know, so that was definitely, you know, that kind of a relationship, technically, definitely. And he at least had teased me about it too, because I was so into it, like it was such an important, he'd like, oh, what if somebody came up with a non-standard markup language and called it ZML? Oh, you know, he used to tease me about it and stuff. So he really had a grip on things, and I knew he was going to become a superhero or a supervillain, you know, and so I introduced him to Brewster as soon as I could, and Lawrence Lessig and Corey, and I just wanted him to know it was so much fun to be on the right, you know, the good guy side of things. And pretty quickly, he didn't really need me anymore. He needed me when he traveled, because they wouldn't rent him a hotel room and stuff, because he was still like 14 or 15 years old at that point. But even our last trip to South by Southwest, he was in the hotel with me in his own room, like down the hall for the first half of it. And somehow he figured out a way to get somebody he figured out a way to rent a room in the good hotel that was across the street, you know, where his friends were. And he's like, I found a way to, you know, can I go to the other hotel, you know? And he was with Wes Felton, I want to say, and a number of people, Justin and Zuko, and people that were, you know, just as good as me as far as having responsible adults around and stuff. And so that was the trip I kind of let go a little bit and let him grow up with his friends.
So one of the things that was really interesting about the CC licenses, and you know, at this time, like Aaron was younger than me, but at this time I didn't know anything about copyright law. Like, I didn't really know about it until I went to college, which makes me like feel like a latecomer to this. But And I didn't know what an innovation Creative Commons was like until I got to know it a little better, because it was just like, by the time I got interested in copyright law, like it had already quickly become a standard. So what do you think were some of the most innovative things that CC was doing, especially in the technical realm?
Well, one of the most important things that I thought, and not just because I was the person that was one of my millions of jobs, but in order to make a website with basically a form on it where you could choose the options you wanted, the terms to release your works, you had to understand what the terms were. What's a commercial use? What's a non-commercial use? What's a derivative work? These were, Corey was talking about these subjects that make people glaze over instantly as soon as you start talking about them. Copyright is like, you might as well be talking calculus to these people. Like, the average person is public domain. Like Brewster and I are sitting around, how are we going to explain to people what the public domain is, right? You can't look at it. People are going to lose it. People could lose it for 18 years. And they don't even know what they might lose because they don't understand what it is, right? And so, that was our biggest challenge, I think. And I myself wasn't yet an expert in that stuff. So I had to understand it well enough to be able to work with Aaron on the data model for it. And that was what I think still is one of the greatest accomplishments I think that Creative Commons has done, is in the sense of empowering authors to make informed decisions about how their works can be reused, and actually understanding, I always tell people when they're starting out, if you don't get it, then just do, attribution, non-commercial, share alike, and then you have to decide about derivative works or not. But don't give anything away yet if you're not sure what you're giving away. And I wasn't trying to tell people to, it was still in the spirit of things because you had the share alike thing there. But you can't go back, right? Once you give it away, it's gone. You can put up a new version of it and say, okay, this one's under this other license. But if you put it out at any time under that license at that time, you're bound to it. So, that was the big thing. And then we thought for software we might need another license, and so I had to comb through all the GPL licenses, or not all GPL licenses, GPL was one of them, all the open source licenses for software. And it took us 2.5 months to figure out we didn't need another license for software. There was 1 million licenses already for software, and because software is copyrighted, we could use our existing Creative Commons licenses. So all of that, and being able to have people, because we launched with thousands of people that had put their works out when we launched, that was a big thing, because we had to have so many licenses at the launch we wanted. How do you explain to everybody in time what it meant so they could choose licenses so we could launch? And have it have meaning, not just talking people into going along with you because they wanted to do open source things, right? So yeah, that was I think the biggest challenge, and I think one of the biggest accomplishments.
I guess one main question to end, when did it really hit you that it was going to be something big, and what were your hopes and dreams for what it would become, what would happen with CC?
Well, that's really funny. I wish I could remember the person's name, but Corey hooked me up with somebody that did a report for us to predict how many licenses we were going to have. And he had charts and graphs and really convincing arguments and evidence. And he predicted something like, 12 million licenses in 10 years or something, which I think we surpassed actually when it happened. But the Creative Commons board thought that we were blowing smoke up their ass. Basically, they were like, oh, you're just trying to flatter us. You don't have to tell us we're going to have 10 million licenses. It's okay, But I was looking at this report, and I was like, it makes sense to me, showing what, is in this report and stuff. And I showed Corey, and Corey's like, oh, that makes sense to me. And so it was sort of hard to believe that adoption could be that widespread, but there were so many people asking for this. Educators, teachers, artists, especially remember the Napster thing was a really hot topic. There was a lot of musical artists that were like, hey, I'm not making any money anyway. I would rather that my music get to more people. And then they did a report that shows that pirated music, shared music, only led to people going back and buying the back catalog for that music artist. So I think that I had pretty big hopes from the beginning because other people were doing the math and it made sense. But then when it happened so quickly, it is still kind of hard to believe.
And I will say, I think the last count that somebody tried to do on the number of licensed works CC had came up at about 2 billion. We've actually got a team of graduate students like helping us like try and get a more accurate count this year. But like, yeah, that's so I think that was a good.
Do it.
So, yeah, like.
So
I think,
let's turn the tables now a little bit. I wanted to ask you about, you were talking about that you're in the works, you have sort of different ways of sharing and branching out into different countries and things like that. And I wanted to know what are the plans now for the future of Creative Commons? What are we going to do next?
Yeah.
What are you going to do next? I still feel like I'm a part of it.
You are still part of it. Like, if you sent us emails saying, I think you should do that, like, that would be extremely persuasive.
Great.
So CC, most people know CC for the licenses. Like, we don't actually have any short-term plans to, like, version the main CC license suite. We're on version number 4. 2002 was the first one. 2004 was version 2. There was like a small revision in between there. 2007 was version 3, and I was actually at CC in 2013 when version 4 came out. And it's been about almost 10 years now. And version 4 so far has been pretty good. We haven't. So what do we do at Creative Commons if we're not making new licenses? And I will say, as part of the team that did version 4, we're not. That was such a big lift that I think we're still recovering. And part of the reason that it was such a big project is version 1 was basically based upon U.S. law. A lot of the assumptions made in it, a lot of the language used, a lot of the rights that were included in it were based on U.S. law. It was just a hack to like deal with this temporary policy problem, and it only took like. It didn't take very long for people in other countries to say like, hey, you know, like this is a great idea. We need this in our country too. It turns out that our copyright law is also broken. One of the things that's interesting about copyright law as opposed to so many other areas of law is that there's a lot of international harmonization because of the Berne Convention, which most countries, almost all countries, are signatory to, which detail like what you have to do in your national implementation of copyright law. So a lot of the things that are broken in the US are also broken in other countries, and even that the US has a much broader system of limitations and exceptions than a lot of other countries do. So some of the things that are broken in US law are even more broken in other countries. The version 2 was like a little bit more international, and other countries had their own versions that would work with their own law. In version 3.0, this exploded. Like there were a couple dozen countries that had their own ported versions that were meant to work with their own national law, and had slightly different language for things like moral rights and database rights that exist in countries that aren't the United States, or slightly different language for how you talk about those rights and how you have to give them away. Which made it extremely complicated because there weren't just, you know, the 6 main Creative Commons licenses. There were like 200 Creative Commons licenses, and like, how could you use them together? Like, we were trying to do something simple, like here's this very simple modular suite, like it's easy to tell how you use them together, but now there's 200 in different countries, like, and everybody usually tried to make that just an afterthought, talking about the Creative Commons licenses. Oh yeah, we have these ported versions, don't think about them too much unless you really have to. And That's not a great answer, especially as a lawyer. That is not a great answer. As we like to think that everybody reads the licenses all the time, and to tell you you have to read 200 of them to understand what's going on is just not an answer that anybody wants to give. So version 4 actually brought all these together. There is one international version, and we talked to lawyers in all the countries that we could find, basically, to say, like, okay, like how can we harmonize this? How can we make one text that works for everyone? And so we had a lot of things that, you know, named all sorts of rights. That's like, if this applies to you, and things like that. And like, if this right exists in your country, here's what you do with it. And then we just had local teams translate it. So we have one official version, but many local translations, and those are actually still happening now. And that was about 10 years ago. So what do we do now? Well, it turns out that having good copyright licenses does not create openness by itself. I know this is like a revolution. This is not a revolutionary thought to anyone, but it's like it was a necessary step. But it turns out that people are putting a lot of barriers to openness that are not just copyright law. There's a lot of things that are going on that are like copyright-like things, or restrictions in the sharing of knowledge are happening in like platform liability, like filtering. They're being put in things like the AI Act and the Data Act. They're being put, and a lot of people are being subject, for example, to contracts that Corey was talking about that limit the way that you can share materials. A lot of people are adopting policies that like are sort of open, but not really. So a lot of what we've been doing is focusing on better sharing, is what we're calling it, and the infrastructure that allows openness to thrive. So recently, about 2 years ago, we got a new CEO at Creative Commons, Catherine Styler, who really wishes that she could be here today, but she isn't. She will be here for our 20th anniversary, and she's arriving like tomorrow, so this is just unfortunate timing. But she spent about 20 years in the European Parliament, particularly advocating for policies that were very pro-openness. And a lot of her focus has been bringing the organization more into the public policy debates to create the infrastructure that will let people create and share in the first place. We've also been sharing a lot of guidance, providing case studies, providing advocacy, like holding the hands of institutions that would like to create policies, because just having the licenses out there isn't enough to say, like, okay, we have the licenses, you can be open access now. It takes a lot of guidance for, like, okay, what are the steps to do this? Like, what do we need to do to make this work? So that's a lot of what we've been doing, and we've been doing training, some general training, and some for specific groups like librarians, like GLAM, the Galleries, Libraries, and Museum, some for journalists, where we give them basically a short course in copyright, Creative Commons, open access, and then those people are empowered to go back to their institutions and it's like, okay, I know how to do this now, I know how this works. So just trying to expand our reach from our, you know, little 20-person organization that tries to be larger than it is, so that we have more advocates out in the world.
Okay, and you were talking about how the landscape is getting very interesting these days with different technologies and things like AI and stuff like that, and that y'all have been thinking about those kinds of licenses, or applying copyright to those kinds of licenses, which sounds so crazy, like AI copyright, but tell us a little bit more about that.
Yeah, so we have a couple areas that we're looking into where it's important to establish like what it is that we mean by openness, or what should the norms be around openness. And one of those is AI. Some of those are around like use of openly licensed images for training data for AI. Like, what does that mean? Does copyright restrict that? Should copyright restrict that? In the US, we've generally said that a lot of this is fair use, but just because you can doesn't mean you should. Like, should we give guidance around the use of those, for example, training facial surveillance systems? And what about all these systems that are doing generative art with works that may or may not be openly licensed? Looking at those problems and like, what do the legal terms say? Like, what do we think the result should be to get the outcome we want? We want artists to feel like that they do have a choice. Like, a lot of what CC is about is giving giving creators the choice to say like, okay, I want to keep these rights, I want to give these away, this is what I want to happen to my work. And do we want those, what does it mean for those choices to be meaningful when like all of a sudden a new technology has changed the way that work? We've traditionally said that AI authors like can't have copyright. What happens when people are using those systems to like carefully reproduce an artist's style, to take things that are recognizable? That's a lot more interesting, and actually we've been engaging with researchers and scholars to try and figure out what should our answer be. You know, we don't want to be copyright maximalists just to make our licenses continue to mean something, but and also like if artists are seeing that use of open licenses makes things happen to their works that keeping a more restrictive license wouldn't, like that's not good for the open ecosystem either. So we're looking at issues like that. Also, a lot of people have come to us recently asking, like, how does this interact with NFTs? Not my favorite topic, because anytime you engage on the topic, you immediately get 100 replies telling you that you're wrong in both directions. But a lot of people are exploring the concept of what it means to own the rights to a work versus what it means to own the token. So we just recently put out some guidance as to like what that means and how you might use it, especially how you might use it if you would like to have your cultural works like in the open for people to use, but you would also like to sell tokens as a way to like make money for your art. And then other distributed web technologies, like what does it mean to have openly licensed works in those areas? So just looking at new technologies, a lot of people have come to us wanting us to create like new licenses for these things, and we've looked and it's like, actually, like, we still think that the licenses that we have are suitable for these cases, but to be meaningful for people to adopt them and not create new standards, we need to be able to understand and explain to people and then give those people education on like what it means to use CC in this context. And that's one of the most fun things that I get to do. Like, here's a new thing, examine it and tell us what it means.
Very nice. Very nice. So do we have our next speakers on the Zoom call? Just to make sure. There's only one if there's anybody, it's them, because they're the only people I've sent the link to. Okay, great. So let's see if there's any questions, and then we'll wrap it up. Are there any? Does anybody have any questions? Okay. What? Oh, I'm sorry. Yeah.
Hey, I had a quick question about the non-commercial Creative Commons license. I know a lot of people, like, for example, like a classic example is like they say that bands like don't make money on tickets, they make money on merch, right? So an example would be like, let's say I'm a DJ or something, and I have a bunch of music that's under a like share alike, like non-commercial license, and I use that music to, you know, be a DJ or whatever, but then after the show I make money with like selling t-shirts that have my logo or whatever, right? My question is like, where is the line of like when I'm using something commercially or when I'm using something to like make money? And like, because I want to respect that non-commercial, but I want to also see kind of what I'm saying. Like, I'm not sure where that line is. And so I was curious if you could elaborate on that.
Sure. So first of all, this is going to be a very unsatisfying answer because my answer is this is always very fact specific, and I am a lawyer, I am not your lawyer, I can't give you legal advice. But that said, first of all, the easy case is if it's your music, like, and you have licensed it non-commercial for the world, it means nobody else can commercialize it, but you can commercialize it like however you'd like. And for a while we were looking at other ways, like are there better things to name it to make it clear what it's doing, like commercial rights reserved, for example. A lot of people use that license who belong to things like collecting societies so that they can still collect revenue from their works and like commercialize their own works but let people share it non-commercially. But if it's somebody else's work and you want to make a use of it and you're not sure if it's commercial, The language in the license is like primarily directed toward economic advantage or something like that, something very close to that. And that doesn't give you a lot of guidance. I would usually say to be conservative. Like, there isn't a bright line. There are some guidelines and examples, but generally, like, if you're collecting ticket sales, if you're making money from the t-shirt, like, associated from performing that work, my guidance to a lot of people is often do something that you wouldn't be embarrassed to explain to the creator or a judge in, like, trying to say what you're doing. If there is, like, money changing hands, like, in connection to the work, something that anyone would say is in connection to the work, I would usually say don't do it. That's probably a commercial use, but also somebody who has put a Creative Commons license on their work, like, they want to share it, they want you to use it. They may want you to use it only under specific terms, so reach out to them and ask them if you're in doubt about the use. But usually, if money is changing hands in connection to it, that's usually commercial.
Yeah, and that's a good test too. If you're so sure that it's a non-commercial use, then write the author. Write the artist and let them know that that you're doing it. If you're making shirts for you and your friends because you're such big fans, you could probably just do that. When I do this thing that lawyers, because lawyers really can't give legal advice, and I am not a lawyer. I just play one on TV when I give people legal advice, because somebody has to tell the people. I decided that some people have to explain some things to people or they're never going to know. With commercial uses, there's two ways to look at it, and I've been on both sides of it. I've been a record company manager where we were trying to get the most that we could out of our artists and trying to get them to sign agreements that included t-shirts and anything we could think of. That's how the contracts look like now, right? They say CDs, streaming, blah, blah, anything they can think of. And now they even say shit like, and all future technologies that are ever going to be created, sign it away now, kind of thing, right? And you never want to sign anything like that. As an artist, you want to make it very specific what you're giving away, and that way they have to come back to you and pay you something else for the other uses. And until somebody explained this to me, because I'm an artist, it was like, oh, of course, And even when I was the record company manager, I kind of secretly would tell our artists, don't sign that. Make us pay for the t-shirts. Now I would hope that you'd give us a bulk deal. We don't want to have to deal with, because there's a lot of accounting and stuff, right? Like you pay for every shirt or whatever kind of thing. But you want a separate agreement for each thing. Now, also a shirt, if you're talking about a band puts their song out under a Creative Commons license, that's for the song. Their logo on the record cover, that's actually probably a trademark issue. That's not even a copyright thing. And so but people say, oh, the song's Creative Commons, so I guess everything associated with that song is Creative Commons. That's just not how it works. And those people, the artist isn't even the one going after you. Oh my God, I had a DJ that played here at Creative Commons in 2019, did some of his new music in his set that we recorded. We put it up on YouTube, and he got a takedown from his distribution company for his own music, for what we put up, because it's just robots doing it now. And it's really hard to get through to a human.
This happens on YouTube a lot, where the artists want more fans, they want to share their work, and their record company is like, no, we people have to pay for that.
Right, and distribution companies specialize in this now, and there are these sort of Nazi algorithms on YouTube that are just, it's just a constant barrage all the time, and there's no fair use on YouTube. That doesn't exist. And they also have this ambiguous Creative Commons license that doesn't really have any, I know officially you won't want to say that, but I can say it doesn't mean anything at all. The YouTube Creative Commons license is complete bullshit. It's not a real Creative Commons license. It doesn't say what the terms are. It's not 1 point anything or attribution, non-commercial, share alike or anything. It just says, woohoo, no license. And almost immediately, people download it, upload it to another account on YouTube and put ads on it. And now they're making money from your free thing. And it's one of the things that we've been trying to get YouTube to understand, that it's a problem. It was almost like you know, we don't really want it there if it's not going to be a real license. When of course we wanted it there because it's good to have it on YouTube, right? So what do you think about that kind of stuff?
Oh yeah, I will say if anybody at YouTube takes issue with that characterization and would like to fix it, please email legal@creativecommons.org, and we will be happy to work with you. That is a great frustration. We want people to adopt the licenses. Having platforms adopt the licenses has been huge for adoption, as creators say oh, I have this option. I didn't know I had this option. I actually want people to use it this way, but YouTube has, number one, buried it in the interface, and number two, made it a little bit meaningless by putting these things in their terms of use that prevent you from actually downloading and remixing. So yeah, anybody at YouTube who would like to fix this, we would love to hear from you.
Fred, we're talking to you, Fred.
I think Fred isn't there anymore.
Oh, he's not?
He's not.
Oh, okay. Sorry, Fred. Fred von Lohman is one of the mentors that I was talking about that taught me. Him and Cindy single-handedly taught me copyright law over dinner so I could write my webcasting article for CNET and become an instant webcasting expert. It was wonderful. And then he went and worked for YouTube, and he'd really got a lot of good things done over there. And he wasn't, I don't think he actually had anything to do with the fiasco that I'm talking about, but it's important to have corporate support. You know, we want that. When Google introduced their Creative Commons search, I was over the moon, you know, because we could actually find stuff. I use that. Oh my God, I use that so often, all the time, you know. Yeah. Anything you want to add before you go to another question?
Oh yeah, one of the earliest adopters of the CC licenses was Flickr, which was just a huge thing for Creative Commons. It allowed so many people to put their works under CC licenses, and they adopted it way back, you know, I think 2005 or so, back in version 2.0. So all these things have been under the 2.0 version of the licenses. We're actually been talking to them. They hope to have their users be using the new version of the licenses sometime later this year. So watch this space.
Hey, that's good.
Yeah, yeah. Flickr was owned by Yahoo for a long time, and Yahoo did nothing with it, basically. And now it is owned by owners who are actually present and care about it and care about the commons. So we're a lot more hopeful for them now.
Oh, great. Yeah, I was just happy that all my pictures didn't go away. There was that scary, there was that scary time you didn't know what was going to happen. Are there any other questions? Okay.
This is not really a question. This is just a report from the field of gratitude for your work. I was contacted by the UC Davis Special Collections Library asking me to authorize a Creative Commons license for a master's thesis, and they put it up on HobbyTrust. It was dead easy, and I'm really grateful that it was able to get out there. So thank you for doing that.
Oh, awesome. So glad you did that. And the university librarians are like almost universally great with CC and encouraging people to make their works open access.
And actually, my master's thesis was creating a student licensing guide for Creative Commons works. And I made a little table, which was just the pros and cons of all the licenses, kind of with the pointy hat and the artist thing like that. San Francisco State was like, we want all of our broadcasting, electronic communications, arts work to just go up automatically under Creative Commons license. Can you show us how to do it? And it was like another dream come true moment, you know, for me. And it's wonderful to see it propagate, because it really lets the academic articles and everything go far right away. You can usurp the and even for academic journal articles that are under copyright by restrictive corporations who shall remain nameless, just for the sake of argument, there's a loophole. The loophole is that you can take a version of the article that is not the final version and put it up on your own website. And then you can pretty much do what you want with it. So remember that when you have a 6-month hold on your paper that you want the world to have, all you have to do is, it's not the final version, man. It's the near final version. Put it up and it's fine. And then it'll end up in in the Internet Archive's Scholar Fat Cat collection of, hey Brewster, do you know how many journal articles are in the Scholar right now?
Tries to have some, 35 million.
35 million?
Yeah.
Wow, I didn't think you were going to say that.
So we think that there are about 110 million known journal articles, and 35 million have been posted on the open web that we've been able to crawl, put in the Wayback Machine, assign a DOI, and make available through scholar.archive.org. And then we worked with scholar.google.com and added, I think, 20 million articles into scholar.google.com, just because that's where people go. So yeah, let's bring public access to journal literature.
Oh yeah. So I think obligatory lawyer comment, like read your contracts, because some of them have gotten wise to this and like make you sign away those rights. I will also give a plug to our friends at the Authors Alliance, who have a lot of great tools for like authors who want to make sure that they don't get stuck in those contracts, like what to look for, tools to use to make sure that you have a better deal.
Hi, I want to ask about licenses for databases. So we have these two pillars. We have open source license for software. We have Creative Commons for art and content. What about the sort of third pillar of community-curated databases, right? So if I have a community that is assembling a list of good vegan restaurants, or a community-run IMDb, or similar, are there any licenses that protect data sets specifically, protect them from being commercially exploited? Thank you.
Yeah. So generally we don't consider, especially in the US, and I am a US-based lawyer, like in the US we don't consider those kinds of data sets like copyrightable. So we wouldn't usually say that like those data sets would be something that you'd put a copyright license on. Like they would be in the public domain, they're just compilations of factual knowledge. That's something where I would usually try to have a community-based solution, something that is like, something where like those people will get endlessly shamed if they exploit your community. And I think other people have more sophisticated ways to suggest, like, but copyright, people love to use copyright as a tool because copyright has remedies that people actually work and that actually work and people actually act on, and you will get things taken down, but it isn't necessarily the right tool for everything. Like the implications of saying like, oh, copyright should be on compilations of factual knowledge is not something that we want to do, even if we think that it is a really like crappy thing to do for people to exploit those community resources like that.
I wanted to build on that question. I work in machine learning, and some of the ideas I've been exploring have been like, can we add a wrapper license to images so that any instance of the image must have gone through a wrapper license that says, oh, you must pay me $50,000 per instance of image, or like an embeddable license that's an image that is in fact a legal document that is then embedded in a trained model and said, oh, you have this license, pay me money, or something like that.
Yeah, so I'm not 100% sure that I know. I guess like what I understand from your is like basically kind of a click wrap license for machine learning, sort of where like you have accepted the license by like loading this image into your training set or something like that.
I think that's definitely a valid way to think about it. I was really thinking a more limited approach, like things that already exist, like there's only one website in the world with this image, and it has a license that you must click accept to achieve, which means that saying if I use this data set or my affiliates use this data set, in a data set I must pay like $50,000 a day or something.
Yeah, so it would be really difficult, like even like getting outside the realm of Creative Commons, it would be really difficult to say like that there was a meaningful acceptance of that license if like you knew that no human was ever going to see it and understand it and agree to it. Even these licenses that you kind of like agree to without really looking at them, or they've been upheld, but they're a little bit dubious. I would not count on that one being upheld in court, and it doesn't. I would try to actually make something that you at least think might be negotiated with a human, even if so many people like click past the terms of use and do not actually read them. I wouldn't count on that being upheld. Training data is a hard one also because we usually think of like in the US particularly, we usually think of a lot of those uses as being transformative uses, like whether or not...
So fair use.
Fair use, yeah. Like even if they're openly licensed, if they're proprietary licenses, like that they can still be used, and if the output is like something that isn't really like, isn't just a reproduction of the work, or isn't like, doesn't have a straight line from that work, but it got all jumbled together at scale, and something like, you know, something came out where you can't, it's not easily traceable back. That's usually considered fair use in the US, and you don't need a license for it. Other countries, the EU is moving towards that direction. There's some, that's going through the legislature in like various ways all the time, but usually that's not something that's a licensed use. If it is something that is going to be directly reproduced in a way that would usually implicate copyright law, like you have made a reproduction, like you are distributing the set, like that might be a different question, but that would be, I don't have a lot of confidence in that hack working, but it might depend on the details, like so much of this stuff does.
Okay, we have to move on because we're already well into our next speaker time, and we're going to take lunch. And so we're going to hear from the new Aaron Swartz Institute in Brazil, and they've been waiting patiently, so we need to move on. But let's hear it for Kat. Thank you so much for being here. Really appreciate it.
Thank you for having me. It's great to be here.